Next, we have the In re Gavrieli case. Christopher Prince appearing for appellants. Edward McNeely appearing for appellee.
Are you Mr. Prince?
Good morning, Your Honors.
Before you start, Mr. Prince, I just wanted to tell you that although there are 3 appeals, we are going to only allocate 15 minutes for the 3 appeals. So you're not going to get 15 minutes per appeal. Okay?
I'm grateful to that, Your Honor.
Well, I just wanted you to know from the beginning so you wouldn't anticipate that you could spend 15 minutes and then say, well, wait a minute, I have 2 more arguments. Why didn't you let me know?
Understood, Your Honor. That was actually going to be my very first question. And again, I'm grateful for the response.
So maybe you could tell us, do you want to reserve any time?
I would like to reserve 5 minutes for rebuttal, Your Honors.
Sure.
I will take these in order of the numbers, 1000, 1001, and 1002. Pardon. Should have had some more water before I got up here. The first one, 1000, I kind of refer to in my own head as control of the adversary's appeal. The second one as the liquidation appeal, and the third one as the borrowing appeal. That's just how I think about them. Overall, thematically, for all 3 appeals, there is an issue of, I think there are 2 overlapping issues. One is, does the plan default mean anything? And 2 is, does the trustee have essentially unfettered discretion with no review by creditors or the court? With respect to 1000, control of adversaries, it's a combination of the 2. The first is, does the default mean anything? To understand whether the default means anything, I think we need to go back to what was the status of the adversaries before the default. And throughout the plan and disclosure statement and all the documents, it says that the debtor manages and controls the adversaries. And I think there seems to be some disagreement between the debtor and the trustee as to what that meant. But if you look at, for example, the disclosure statement, which is at ER 67, and I'm looking at pages, ER 66 and 67, I'm looking at pages 55 and 56 of the court numered docket at the top. It describes the debtor's management and control of the state court litigation, and then describes the PED's role for the equitable subordination with those exact same words, manage and control. My perspective is that pre-default, the debtor was the client, was suing in the name of the post-effective date trustee, but was akin to someone who had been assigned for collection or an insurance company with subrogation rights or some other role where, yes, the name on the pleading is post-effective date trustee, but the debtor is the client. And the question is, post-default, does that change? And the bankruptcy court punted and basically said, it may have changed a little, but we don't need to worry about that. And I don't think that's a tenable result, because attorneys need to know who their clients are, and they need to know who their duties flow to, and clients need to know who their attorneys are and what those attorneys' duties are, and litigants are entitled to know who their adversaries are. And it has direct relevance, for example, in the context of discovery, which was the bankruptcy courts ruled that the post-effective date trustee, as the litigant, doesn't have any obligation to get information from the debtor, doesn't have to collect information from the debtor to respond to interrogatories, doesn't have to collect documents, on the basis that the debtor is separate from the post-effective date trustee, even though the debtor is managing and controlling litigation. So the default provision specifically says that the post-effective date trustee takes control of the assets and no longer has to consult with the debtor. And I suppose hypothetically, the trustee might make the argument, yes, I have taken control of the litigation. I control it. It's mine. And I've decided to sort of bless the debtor with some undefined day-to-day management, but that's not what the bankruptcy court ruled. That's not what the position that the trustee advocated at the court below. And I also think that fundamentally that's an untenable position as well. Moving to liquidation, this again relates to these two issues, the trustee's discretion and does the default mean anything? I'm going to focus primarily on, I think, the two a little bit more complicated issues in the sense that the cryptocurrency, I should say not more complicated, less complicated. This is possibly the most volatile asset class I've seen in my lifetime. I've probably maybe, what are the things from the Netherlands 500 years ago, the tulips? That may have been more volatile, but crypto's right there with it. During the course of this case, it's gone up 200% and down another 50%. And this is something where I do not think a trustee of a trust has unfettered discretion to maintain what is essentially all of its cash in that kind of non-interest bearing, highly volatile asset class. And particularly when it's using it to deleverage borrowing at a high interest rate. The second is the Hong Kong funds. The plan states that the estate will bring them back, but then it clarifies that means the debtor. The trustee essentially takes the position we should ignore that part. Even if we did ignore that part, it seems to me what the trustee has described as a lengthy and expensive process to try to go to Hong Kong, open proceedings in Hong Kong, obtain a judgment in Hong Kong when this court has jurisdiction of the debtor and can compel the debtor to return them. The argument is that the debtor doesn't control it, but we've seen there's nothing to suggest that the trustee has done anything to verify that. There's no Rule 2004 examination. There's no report to the court about how it was investigated and declined. They've tried to place the burden on my clients to prove to them that the debtor has control over the funds, but that's not my client's job. And the third one is borrowing, and this is the one that actually has nothing to do with the planned default because the borrowing occurred before the default. And this has to do with the trustee's discretion. And it occurring before the default is critical to why it's an abuse of discretion. Prior to the trustee being aware that the planned backstop was doomed to failure from the beginning, the trustee had the ability to borrow on the backstop on a subordinated basis. Rather than do so, the trustee borrowed on an unsubordinated basis millions of dollars from, among others, the debtor, the debtor's mother, and the debtor's creditors, and a crypto lender. This was not contemplated anywhere in the plan. And I think much like the case in Texas, and I apologize for blanking on the name right this second, but in that case, the plan and disclosure statement were silent, but the court still found that type of highly unusual arrangement was just not authorized. The plan not contemplated and not adequately disclosed to creditors or the court that could occur. Here, the plan actually specifically says that the trustee may seek a further backstop, but it must be subordinated. And if you read the transcript, the colloquy with the bankruptcy court was, the court described it as squares and rectangles. But what I have not heard is what makes one a square and what makes one a rectangle. Further backstop is not a term of art. It's not a legal term. It's not a Latin term. It's not even an actual term in any credit agreement, the backstop, what is called the backstop, has the term revolving credit agreement. What is it that makes a further backstop different from any other kind of borrowing, except that one is subordinated and the other is not? And from my view, that's tautological. It's basically defining the result by the definition. I'm going to stop at 5:55 because that seems like a good point. Thank you, Your Honors.
Good morning, Your Honors. Edward McNeely from Hogan Lovells Cadwallader on behalf of J. Michael Issa, the post-effective date trustee. I'd like to take a very brief time to put all of these three cases in context. The Chapter 11 trustees' plan provided for the creation of a post-effective date trust to administer the estate's assets and the appointment of an experienced independent fiduciary, Mike Issa, to serve as post-effective date trustee. There was a backstop contemplated to provide liquidity. The backstop performed, but then failed unexpectedly. The Chapter 11 trustee was smart. The plan and trust agreement gave broad discretion to the independent post-effective date trustee to manage the estate's assets and funding, and that is what he's been doing. And ultimately, we view all three of these appeals as seeking to rewrite the governance scheme and the plan that Judge Bluebond confirmed, and to reallocate away from the post-effective date trustee three core functions: control and counsel for the trust litigation, the timing and funding of the trust administration, and the means of financing it at the request of subordinated creditors who were the trust litigation adversaries, and indeed were the only adversaries and opponents of the Chapter 11 trustee during this whole case. So I'll turn now to what we've called the conflict appeal of 26-1000. We don't think the court even needs to get to the merits. We think you could simply throw this out on the basis that it's interlocutory, that there's a lack of jurisdiction when you have a bankruptcy court determining matters of conflict, and also that the Unitons aren't persons aggrieved for terms of appellate standing. But I'll turn to the merits because Mr. Prince addressed those. On the point of control and management of the litigation, Section 4.2 of the trust agreement is a distribution provision on default. Section 1.4 of the plan and Section 3.4 of the trust agreement do allocate management and control of the adversary proceeding and the state court litigation. And to be clear, the equitable subordination proceeding is not part of that. There's nothing in the plan or the trust agreement that changes that on default. We do think that ultimately the post-effective date trustee has the ultimate power to resolve these issues. But where we think that the rubber hits the road is that Section 4.2 has no impact on the ability of the post-effective date trustee to use the debtor as an agent of the trust. That's set out in 3.15 of the trust agreement. The adversary relates to the company that Mr. Gavrieli is familiar with. In the state court litigation, the Unitons had originally sought a judgment of several $100 million. They ended up with just $17 million. They filed the adversary proceeding. The independent Chapter 11 trustee found it to be meritless, and he filed a motion to dismiss. And that's at BAP 26-1000, 81 to 86, his findings and investigation. Mr. Issa's continued with that litigation and has been satisfied with Mr. Gavrieli's role. And the proof of the pudding's in the eating. Of course, these bankruptcy cases have continued on since these appeals were filed. There's a summary judgment proceeding, a summary judgment hearing in the adversary proceeding in just 5 days' time. And since the appeals were filed, there have been two sanctions orders in the adversary proceeding granted against Mr. Prince's clients. And Your Honor, Mr. Prince, at ER 471, he conceded in the hearing that he does think that the court's interpretation is correct, that the trustee would have the power to come in and override Mr. Gavrieli, but he remains in control of the litigation. So we ultimately think this is much ado about nothing. There was no daylight between the Chapter 11 trustee, the post-effective date trustee, and they're pursuing this litigation. And Your Honor, we note that Mr. Prince has not even addressed the issue about Houston Hennigan. We think he's abandoned that issue, and we think it's clear that there's no no conflict there either. This has again been the Chapter 11 Trustees Council, the Post-Effective Date Trustees Council. The court found, made as a factual finding, that there was no concurrent representation, that the post-effective date trustee is the client, and there's no basis or reason for the court to overturn that. Moving now to 26-1001, what we'll call the liquidation appeal. And 4.2 of the trust agreement is an important provision. It, of course, is a provision that applies on default. And it says that the post-effective date trustee has the sole discretion to determine how to maximize the value of the assets, and also that he is to liquidate the assets as promptly as reasonably practicable, consistent with seeking to maximize the value of the assets. That's not a forced sale provision. It's not an immediate liquidation provision. So turning to the specific issues raised by Mr. Prince, with respect to the cryptocurrency, the post-effective date trustee filed a declaration in the court, a very, very experienced post-effective date trustee. Mr. East is a fellow of the American College of Bankruptcy Counsel. He's been doing this for years, explaining what he'd done with respect to the cryptocurrency and Gavrieli brands. There have been multiple status reports to the court as to why he's been doing what he's been doing. The post-effective date trustee, or rather the Chapter 11 trustee, didn't sell the cryptocurrency either. And while we recognize crypto as a volatile asset, there is no per se rule that says that a trustee must sell cryptocurrency. If that were the case, every single one of the crypto bankruptcies, FTX and Celsius, they would have had to liquidate the crypto on day one. And that's not what happened. Turning to Hong Kong, Judge Bluebond ordered the post-effective date trustee to begin pursuing the approximately $13 million in funds as expeditiously as possible. And again, with the theme that these are ongoing cases, that's exactly what the post-effective date trustee has done. We referenced in our brief that we'd obtained an order from Judge Bluebond to help us get assistance from the Hong Kong court and a letter of request. We got those. Our Hogan Lovells, my firm's Hong Kong office, has filed applications for recognition and assistance with the Hong Kong court. That's due to be heard July 29th. So we think many of these issues are moot.
With regard to the Hong Kong accounts,
with regard to the
it appears that there was relief granted in part.
There was, yes. So the post-effective date trustee did not oppose the tentative, and in fact, if you look at the colloquy at the hearing, Mr. Prince rested on the tentative in that case as well. The post-effective date trustee has gone ahead and is pursuing the Hong Kong funds, has taken that action. And just briefly to address the issue with respect to the debtor. No, there's not been a Rule 2004 taking. We've asked the debtor multiple times. He's denied having control of it. And of course, we're not just saying, oh, I asked someone and he said he didn't have it. But we could put him under a Rule 2004 and we get the same answer. The Chapter 11 trustee found no evidence of the control. We didn't put Mrs. Uniton under a Rule 2004 either. I think the court has read the background and how the funds ended up in Hong Kong. And from our perspective, what matters is the post-effective date trustee is going ahead and he's trying to get them. And of course, a final point on this is that the post-effective date trustee needs to have the funds and means to do these things. Again, I didn't hear Mr. Prince argue at all. Which I think was an untenable argument in the papers, that the post-effective date trustee shouldn't be allowed to pay professionals to do the work. The plan in 1.90 provides that those are trust expenses. You're all experienced bankruptcy judges. For better or worse, professionals don't work pro bono. And so we have to do what we have to do, and necessary fees will get paid. Finally, with respect to what we've called the unauthorized borrowing motion, 1002, there are 4 separate transactions here that are challenged, and I think it's important to delineate them because Mr. Prince has conflated them. The first is the deferral of the debtor's stipend. And Judge Bluebond found, and I'm citing, again, this is the cite to the 1002 briefing at ER 267, there's no deferral or subordination of that. It can't qualify as a borrowing. And that's absolutely right. That is a senior trust obligation. And if you take that to its logical conclusion, anytime the trust doesn't pay something cash on hand, that would be borrowing, and that's simply not the case. As to the question on the crypto loan, Mr. Prince raised the question about the timing of this, and let me take one step back. First of all, with respect to the issue of authorization, because before looking at particular transactions, we need to determine, well, is the trustee authorized to do this in the first place? And if you look at section 5.2 of the plan, it says that cash required for payments can be made from borrowings, most notably the plan backstop. It doesn't say only the plan backstop. Section 4.4 of the trust agreement permits proceeds of borrowing under the plan backstop or any other source of funding for the trust or estate. It doesn't say any other subordinated source of funding. So there is a flexibility built into that. And again, I credit the Chapter 11 trustee and his counsel for doing that. So given that it is authorized, the question is then, what can the trustee do? And we've cited several provisions. 2.2 of the trust agreement, the trustee's reasonable discretion. Section 3.12, any good faith determination by the trustee as to what actions are in the best interest of the trust are determinative. So if it's authorized and it's in good faith, that's determinative. Now, why did he do what he did? So Mr. Issa did make a request to the backstop to fund the January 2025 plan payment, but he was asked to hold that request because Mr. Sandberg and the backstop was in the middle of a refinancing. That's cited in the transcript and the colloquy in the hearing at ER 268. And if you've been reading that transcript, Mr. Wen Tan from Mr. Issa's office was conflated with my colleague, Mr. Wynn. So it was Mr. Wynn arguing, not Mr. Tan. And Mr. Issa had no reason to doubt the backstop because he had a great track record. $4.29 million had been borrowed under the backstop to date in the plan. Entities affiliated with Mr. Sandberg had borrowed $6 million pre-petition, and those have been repaid. And I've referenced, again, if the panel needs a cite, those repayments were at in 26-1000 to ER 56. But we said again, the Chapter 11 trustee was very smart in building in this flexibility to the plan. This allowed for Mr. Issa to solve this problem by monetizing the cryptocurrency by borrowing against it. And again, Section 3.1, monetizing is permitted. We've cited to several cases, including, I think it's a case from the Eastern District, I think it's a Judge at Whitman, a case from the Eastern District of Washington, the Shoot the Moon case.
Yeah, Judge Holt.
Judge Holt, sorry, I'm getting his first name wrong, conflating those, where monetizing, an example of that was borrowing. And then with respect to the others, this is not a situation of an undisclosed situation. You have other creditors of the estate, most of the other creditors who loaned back their initial distributions at a favorable rate to preserve liquidity. With respect to the litigation, the adversary proceeding, that was an interest-free funding. And again, I go back to bringing all of these together. The proof of the pudding is in the eating. We have an adversary proceeding that's ripe for summary judgment. We, of course, believe that the trust will prevail. If the trust wins an adversary proceeding, that will trigger a right on behalf of Mr. Gavrieli, and by conflation, the trust, to seek an indemnity claim from the company Gavrieli Brands. And if the court needs a cite for that, the definition of trust assets in the plan includes indemnity claims against the company.
Let me just interrupt you for
course.
1 second to ask,
Yes, of course.
what do you think the standard of review is in this case?
We think the standard of review is abuse of discretion because you're reviewing a bankruptcy court's interpretation of its own order. This
What
is not
order would that be?
So there are three, of course, separate orders with respect to interpretation of plan and trust agreement issues. For all three, we believe the standard is abuse of discretion because it's Judge Blueborn reviewing her own order. She's not interpreting a statute. And then breaking individual components down on BAP 1000 issues regarding conflict, whether an attorney is conflicted. I think that's black letter case law, that is an abuse of discretion standard. Determination if someone is an agent, abuse of discretion. And then on 1000 and 1001, on 1002, again, for both of those, we think that the interpretation is abuse of discretion. Even if you apply de novo review, we believe Judge Bluebon got it right. But once you get there, the question is then, okay, assume X, Y, or Z is authorized. She got that right. Did she abuse her discretion in determining that a particular action was beyond the pale or that it was acceptable or not? And with respect to those actions of the trustee that we've described, we think that is reviewable for under the abuse of discretion standards. So we think you need to separate out what does the plan say? We think it's abuse of discretion, but even if you apply de novo review, Judge Bluebon was right. And then looking at whether she was right or wrong to authorize individual actions, that is reviewed for abuse of discretion.
But if I can ask one other question, that is, it seems to me that throughout the brief and throughout your position and what Judge Bluebon's order seems to rely upon is our interpretations of the plan, not any orders that she's issued. It's constantly going back to, say, paragraph 4.2, paragraph 3.1, whatever. And the plan itself constitutes a contract. Interpretation of a contract is typically reviewed under de novo review, not abuse of discretion. Now, I agree with you that once you get past the de novo review, I guess the question becomes, do we then change to abuse of discretion standard to determine if her decision is consistent with that, or do we say she had the right? We don't think that she was wrong about what she said. It appears that she's interpreted the contract appropriately, and affirm on that basis.
That's right. And Your Honor, I would, again, briefly from the argument, I mean, we have, of course, I've argued under abuse of discretion, but I've also tried to tie the argument very concretely to the plan and the plan provisions and the trust agreement and what they say. So whether the court goes under the abuse of discretion standard or de novo review, we do believe that you can affirm on either basis.
Okay.
Thank you very much.
I'll address the review standard since it was just mentioned.
Sure.
I do agree with the panel's perspective, which is it's de novo. It was all related to the plan and trust agreement. I guess if I try to articulate the trustee's position, it would be, well, the confirmation order confirms the plan. But if you kind of bootstrapped that into interpretation of your own order, then there would be no de novo review of plans. So I don't think that's tenable. The court never mentioned once any provision of the confirmation order that affected the decision one way or the other.
Independent of the plan.
That's right. The trustees council said that 4.2 is a distribution provision, and that's not accurate. And it relates actually to a couple of issues. The 4.2 contains a specific reference to no longer needing to consult the debtor. And the reason is, and this relates to the crypto loan and the pre-authorized borrowing, prior to the plan default, the debtor had a veto power of any decision of the trustee with regards to liquidating assets or doing anything to do with estate assets. And so at the time that the trustee made the decision to take out the crypto loan, the trustee was not exercising his personal business judgment. The trustee had to consult with and obtain the permission of the debtor. So this is no longer a situation where the trustee has independent business judgment to exercise. The trustee has to work in conjunction with the debtor. And this relates to the issue of the plan backstop, which is counsel said that the trustee had no reason to doubt it. I don't believe that issue's been litigated or is in the record. But what is in the record is there were substantial delays in the payment. One was at the request of the debtor and the trustee. The plan was modified and it was delayed. And then there was a follow-up where apparently Mr. Sandberg said that there was some transaction going that would prevent distribution from the backstop. Well, red flags maybe should have been going up at that point. But there's nothing in the record to say the declaration does not include some description of investigation or here's why I thought there was no problem with the backstop. I think that's possibly the most troubling aspect of this is that substantial delays in drawing on the backstop when it turns out that the backstop was based on a giant fraud. In terms of the issue of the court's rulings were very specific in terms of the debtor's control and the trustee's control. The court did not rule that control had shifted to the trustee and the trustee was authorized to delegate. That's an entirely separate issue. The court ruled that it did not appear anything had changed, except perhaps, maybe, we don't know, that the trustee could come in and overrule the debtor on something. And that's why the Houston-Hennigan issue becomes so critical. And the discussion of Hong Kong illustrates that. Houston-Hennigan was the trial counsel for the debtor when the issue of ownership and control of the Hong Kong funds was litigated in the state court. It was fine for them to continue in actuality as the debtor's counsel in controlling state court litigation because they're advising the debtor. But if they shifted to now be the trustee's counsel and now have ethical obligations to the trustee's counsel, how can they execute those duties with respect to the Hong Kong funds? How can they give candid advice to the trustee about actually, trustee, here's all this really damaging information that's in the state court record that you should consider about whether bringing a contempt motion against the debtor. They can't give that advice. And the trustee can't expect them to give that advice. And so that's where the conflict comes in. The conflict is a newly created conflict that arises out of the plan default. Pardon me. I think I can make it to the last minute. With regard to the argument about the cryptocurrency, that FTX would have to immediately liquidate all its cryptocurrency. FTX was a crypto business. And they were in the business of holding crypto. They were in the business of dealing with it. Now, I don't know if the court can take judicial notice of this, but FTX did liquidate quite a bit of cryptocurrency during the course of it, and they had a plan for doing that. This is not, the debtor is an individual person, and now the trust is a trust for the benefit of creditors. It's not a crypto business. And they were holding it as the equivalent of their cash. This was... no Chapter 7 trustee would be allowed to hold the cash of an estate in crypto. No, certainly not for years. And this goes back to the idea that this was the debtor's decision not to sell the crypto. The Chapter 11 trustee and under the plan, the debtor had the right to veto the crypto sales. So it wasn't until the plan default that the trustee had unfettered discretion to liquidate, and the failure to do that has cost the estate millions. Thank you, Your Honor, unless you have any questions.
No.
Thank you, Your Honor.
Thank you. I'll take the matter under advisement. Thank you.
We'll issue a decision as soon as we can. Thank you.